All right. So I am here. You probably hear harsh reality in the background talking. That is because I am watching his channel as I'm, searching for the hearing. Um, I know I'm on the right YouTube channel because Hey JB and other YouTube channels, WFLA News Channel, Long Crime, they're all showing the same image. So we're just waiting, just like everybody else is waiting, I suppose. I think you know I think I'll talk a little bit about a kind of a short issue that I can quickly end if once they finally get the hearing started. um and I think what's really on my mind right now, I think I'm still set on private too. I need to take that off. No, it's not. It's public. Save changes. um One of the things that's really been on my mind has been the obviously the three friends that were found frozen in the backyard. Well, hi, Zelda. Zelda, how are you? This case really freaks me out because I had a murdering monster cut my window screen, but then my cat woke me up. Yeah, the domestic violence, this is the Idaho 4 case. The early belief was that someone in the group of four, that they may have had a stalker, right? And that we kind of got this feeling that there was an incel who was stalking one or several of these girls, and it became violent out of jealous rage. That was, or a serial killer with sexual excitation, that kind of thing. So that was that was the initial reaction to the murders. I definitely think that as time has gone by, things have changed that have opened up to other very real possibilities. And it's very difficult for me to ignore this altercation that happened with Ethan with some other fraternity guys. That is hard to ignore. That bothers me. I think that provides a real path toward motive for someone. We don't know what they were fighting about, but it does seem like the disagreement was happening with Jack Showalter's old fraternity before they kicked him out. Jack Showalter himself is hovering around the girls, escorting the girls. He seems to be there in every picture of them during that night. There he is, hovering. He, in fact, did leave. The question the FBI or law enforcement always ask, is there somebody who left town early? Is there someone who was acting suspiciously in the days after the murders? Well, Jack Showalter did. He, in fact, probably left about the time that these murders happened. He left. He drove to his parents' house and then went to a cabin. There was discussion that in the day or two after he arrived at the cabin, he got an airplane and he went to South Africa, where he has family land and family property. So yeah, I mean, that is a real thing. And yes, the cops came out and said, we have cleared everyone. Everyone was cleared in like 36 hours. So it kind of bothers you, that they were so quick to clear all these people. So I think, Jack Showalter, the fraternity disagreements, the arguing with Ethan, Xana, and some people, yes, the cops know who it was. The fact that for a long time, we didn't really know where Ethan and Xana were at. And I'm not really altogether sure that that's going to turn out to be fact once this trial starts. So that is one possibility. So there's the stalker element, incel, psychopath, stalker. That's one possibility. Other possibility is just good old fashioned anger and revenge resulting from the disagreement that Ethan and Xana were involved in, the confrontation they were involved in. Another possibility, though, is Jack D. I noticed that, and other people talked about this, certainly that their conversations led me to go look. And then I was like, oh my God, it is the same. That the guy that the security picture, security photograph shows Kaylee and Madison talking to a guy on a bar stool that's wearing a hat. It's got an M, a baseball cap on it with an M. When you look at the security camera at the apartments, you see a car pull up and a group of guys and a girl get out and walk to the apartment. One of them hides his face, keeps his head down. He's dressed exactly like Jack D. Exactly. And there was some animosity and there was some anger in those moments. You can hear his voice. He seems highly controlled, but very angry. And he says something like, I really hate to be that guy. And then all of a sudden you hear bam, 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 bam. And you're wondering, what were you so mad about, Jack D? So we saw also the look Steve Goncalves gave to Jack D on the stage at the memorial as Jack D is hugging Kaylee's mom. We saw that look. Anybody who says we didn't, anyone who says there was nothing to that look, that it was just an innocent, oh yeah, everything's okay, Jack's helping my wife, you're not being truthful. There was unveiled fury in Steve Goncalves' face as he looked at Jack D. True. So I don't know what he's so angry with Jack about, but I think he's clearly angry. I think that it is really disconcerting, the phone calls, the text messages between Kaylee and Maddie, all messaging Jack, begging him, Jack, we share a dog. Jack, we're friends. Jack, we've known each other. Jack. Was Jack freaking out? Was Jack angry? Or were they calling Jack saying, we need help. There's someone here. We're in trouble. Please come help us. And he never answered. So, man, it's a pretty terrible case. And we really, at this point, the things have divided up what I think are in two really solid camps. And that is the people that say Kohberger is completely being framed, and the camp that says, no, they got their man. So I posted this story. Kat Tish alerted me. It was what led me to become a sheriff deputy in 1973. So I'm unable to handle this case, too close to my own experience 50 years ago. I'm still freaked out. I'm so sorry, Zelda. My stalker is in prison for life because of his dad's carpet cleaning business. I was almost the third victim, but my newly acquired cat woke me up. Larry was out with his ham radio. Wow, Zelda. Well, I'm so sorry that happened to you. It sounds really, really bad. So they're pretty late, aren't they? The judges. I mean, JB is still just talking, and I guess I can unveil morning hearing to unseal is denied. Kaylee's mom said Kelly was found in, here's some new information. Kaylee's mom said Kaylee was found in a sitting position, slumped over on the bed. Didn't know the open court in Idaho is still closed and sealed. Yeah, so nobody's watching this yet. It's still completely sealed. He's no intention of live streaming for the public. It's a ruse. You don't know if it's a ruse. Thank you for all the support. Imagine Bryan. Another person says, I can't remember a single time I ever went to court in Idaho and it was on time. So there's a local who says that the courts are never on time in Moscow. My stream stopped. I'm paying for my entertainment. All right. So still, it's not, they're not playing. It's not open yet. So what we're waiting on, in case y'all didn't know, we're waiting on a Bryan Kohberger hearing in Idaho related to the murder of the 4 University of Idaho students in Moscow, Idaho. Bryan Kohberger's attorneys, this is another attempt to dismiss the murder indictment. And it's only been 3 months ago since they made the same type of appeal. No, it's not an appeal. They asked the judge to throw it out about 3 months ago, and he denied it. Tom Webster says BK is going to tell the judge, ignore my DNA. There's a lot of people that have a trouble with that knife sheath. Where is it? Okay, so we're still waiting. It's also interesting when you look through all of the comments in the news feeds. People are saying things like Ann Taylor's a piece of trash. Ann Taylor's a horrible person. Ann Taylor being the defense attorney, correct? I don't know. What do you think that is about? Why is a defense attorney being a horrible person when it is in fact, determined by the United States Constitution that everybody is entitled to a defense? Isn't she just doing her job? I think it's really interesting that I'm looking at some other make sure we got the right channel. I see the order. Yeah, that leads to the same channel. Oh, thank you. That's been a long time since they had those in, hasn't it? All right. So we continue to wait. Yeah, in November. So, Ann Taylor's just doing her job. What do y'all think? Do y'all think that she's a terrible person because she's providing a defense? Wait a minute. I think it's live. Why are we not seeing it on our connection? Court. Why do I have to sign in? I have to sign in? Damn it. Y'all better go to another channel to watch, because I haven't paid for this or anything. I guess we could watch through. Here we go. got it now.
A claim of inaccurate instructions to grand jury. Also, coupled on that is the potential for permission for appeal.
If y'all can hear that, put a 1.
Interlocutory order. So, and a stay of proceeding in the case. I think that's all the preliminary. Ms. Taylor.
Thank y'all. Very nice. Thank y'all.
Okay, Mr. Logston.
I'm going to be quiet now.
I'm going to, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out 2 factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point.
I totally agree, sir.
There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate.
Agreed.
It's time for a trial, Your Honor. Thank you.
Absolutely time. Long overdue.
Mr. Lawson? Why?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank
you. Excuse me.
Well,
first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion.
I think it was correct too, Judge.
Went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this.
Alyssa looks a little irritated.
The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it refile it, as Mr. Knight said. So that's significantly more delay. So there's some other, actually, this is in a case law, Idaho versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, but obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
You want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone, is just simply appealing to raw emotion, and it has no place in this courtroom. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as your honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr. Thompson. Ms. Taylor?
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Miss Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that she was looking at Dropbox.com, and 51 terabytes of our discovery. To put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those, or 500 hours of high definition video, and we just have 1 of those. So 500 hours times 51, or 6.5 million document pages, and that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just 1. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it, but that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well, less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub files. And I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case. And I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor, that is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then get them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those
a
things.
savory snack?
Your
or
Honor,
a
summer
sweet
of
snack?
2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June of 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be, because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information.
I think Judge is
things
going to
that
need an
cast
Adderall.
agents and other
He looks
specialists
like
with
he's
the
about to
FBI
go to
might
sleep.
have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So
Sure.
I understand this. I mean, I'm aware of amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines?
Yes, it's a
Happen
great idea,
faster
Judge.
So that we can get this trial sooner?
Not another year.
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. if you could tell me that, then I would say I could be ready by March of 2025.
Oh,
And that's
my
me saying I'm
heavens.
going to spend
Oh, my
every
heavens.
possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team.
Wow.
But my problem is that's best case scenario if we don't run into problems and delays, getting records or getting people to
This
talk to
is not
us.
right.
And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
You're nervous with 2025?
This is priority for everybody. And I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time.
Totally,
So
Anna.
it doesn't come back. We can only predict the future so much. I only have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000, I didn't count them, but there are thousands and thousands of tips, most of which are out there, but you're right, all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them. That there won't be undue interruptions in the community that could cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but
Yeah.
I know we're not arguing about that.
And I don't think that's going to change anything, Judge. When
Oh, really?
this case has national, if not international, attention.
Okay, but there are
This
parking
spring, I
lots,
was at
hotel
an
rooms,
Association
and
of
other
Council
places.
of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning.
What?
I have people, friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case.
What does
It's
that
not
matter?
Moscow. It's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems.
It's going to solve your
and the state's
your
position on
parking lot
venue
problem.
is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first.
You don't have a parking lot, is what you said.
There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-location. Said, "What are you talking about?" So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of
That's
lodging.
your complaint about
But I think
Moscow is
that's-
lodging and parking.
That is a
space.
practical observation on this case. It's not just here. It's not
That's
just
so
Moscow. It's not just
dumb.
Lake Charles County.
This is so, wow.
Thank you, Mr. Thompson.
Wow.
So you're saying,
Like,
looking at
park
this
and ride.
realistically and the amount of information, evidence, non-evidence, that's might be looking at summer of 2025?
I'm saying that could be where we end up, Judge.
No,
I am
Judge.
still concerned about the
No,
victims
just
and their
change
families. I
venue
mean, they
to a
have
bigger
suffered
town.
for well over a year now with a lot of uncertainty. And that's painful. It's an everyday reminder. And they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once.
This is the biggest stall tactics, and both are doing it. It's like watching T-ball when you think you're going to watch the damn World Series. His complaint was about the high school is across the street and the parking lot serves both locations. Remember? So it's got to be in the summer so that school is out. And what are we going to do if there's a football game for the college? Then we're not going to have a hotel room. His complaints, the prosecutor's complaints, were about space, facilities. So then they're saying, the judge says, oh, okay, so really what we're talking about is change of venue. We need to go to a bigger place that can accommodate all these people. And now he is saying, the prosecutor himself is saying, no, we could totally handle it. We just need to do it in the summer of 2025. I wonder if he's calculated this. Ann Taylor just said it was going to take, what'd she say, 12, 14 weeks? Is that what she said? Last time I checked, that's longer than the summer vacation in a school.
That doesn't come back on appeal, that doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah.
Judge, you can build a damn
Um,
parking lot in 3 months.
I
Wow.
don't want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible.
It is possible. Be a man. Take
I'd really
control.
like to do this sooner than later.
Come on,
maybe-
Judge. Be firm.
In March 2025, which
No.
that would be a reach.
It's ridiculous
just
to go to
wanna
2025.
percolate
This
a
is
little bit. I
ridiculous.
know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long. But
Oh my God. Oh my goodness.
it's really hard for me right now to set something in 2025.
I
Even
feel
though
like
that might be
like
just the
we're listening
reality.
to John Pryor on steroids.
And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future.
Take control
If
of
that's-
this, Judge.
What is the right thing for everything to do it correctly? maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal, and that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward.
That's exactly correct, Judge.
It's hanging over your head. So, sorry.
No, don't. Oh my God. Oh,
Let's see. All right. So I'm going to contemplate a little bit.
Wow. Well, there's that. So we get no, there's no resolution. There's no resolution other than let's put it on the back burner. Let's see what the future brings. I'll tell you how I am so incredibly frustrated. I think Ann Taylor's doing what defense attorneys do, right? You delay. You want to try to let the case age. Helps with jury selection, things like that. So it's hard to be irritated with her, although I'm a little bit irritated, but my irritation is with the prosecutor. That's where my irritation is. What was that damn T-ball move of standing up and saying, well, we don't have a parking lot. What are we going to do? We need a parking lot. And if there's a football game, what will we do with our witnesses? We need a hotel, Judge. What are we going to do? Have you guys ever heard anything so inept and incompetent in your life? That was shocking. And then, of course, every single one of us here in our minds were thinking, change venue. That's what he's getting at. That the infrastructure, the facilities in Moscow and the surrounding areas are just not able to account for a 3 or 4 month trial, correct? We're thinking change venue. You got to go to a larger metropolitan area to do this trial. And then as soon as the judge says exactly what me and you were exactly thinking in our own minds, then he like acts startled and he goes, oh no, I don't think we need a change of venue. We can definitely get a good jury here. We're not worried about a jury. And I'm sitting there thinking, sir, you didn't say a damn thing about not being able to seat a jury. You were talking about a place to park your damn car. And that is exactly right. You can build a damn parking lot if that's really the issue, or you can set up a damn park and ride if you need to. You can bus people in if that's what you need to do. You're in the middle of damn cow country, for God's sake. Park in the damn pasture and get a bus to come pick you up. This is so, oh my goodness. This is like, this does not inspire confidence. What do you guys think? Do you think I'm overreacting? This is pretty incredible. Thank you, Sheila. Thank you. Sheila says, this is crazy. I'm so glad I'm not the only one that thinks that. Wow, I am amazed. I'm amazed. I can't wait to see what Scott Reich has to say about this. I can't wait to hear what he has to say. Incredible. Man, oh man, oh man, oh man. So there is a link if anybody wants to come up and voice your frustration along with me. Man, I am blown away. Well, right, Much Endeavors. I think about the Goncalves family. This is killing them. Those poor people, they were this really tight knit, family, close. It is, what Sketty Nona? I don't know what this is. So Sketty Nona says, is this a stall tactic or are they being petty? Well, in order to be petty, try to remember this too, Sketty Nona. Remember what they did with the house. Remember? They said, no, we'll wait. We'll wait to tear the house down till after the trial. And then at the end of the year, between Christmas and New Year's, with no warning at all, they destroyed that house. Boom, done. Just done. And then if you go over to Truth and Transparency, Lana had the documents that, was it Truth and Transparency or was it Drip Drop? I don't remember which one it was, but one of them, go to each of those channels and check. One of them had the documents. And now that I'm sitting here, I'm thinking that it was Drip Drop. He had the documents. He filed some FOIA request, and he got a FOIA request for the company that did the demolition of the house. He didn't do a FOIA request for Bryan Kohberger or for the attorneys. He did a FOIA request for the demolition company. And what he learned when he did that, he actually got the bid that they made for how much it would cost them to tear the house down, what all they would need. And I am talking about within 3 days from having that bid, they were tearing that house down. It didn't matter that they had told everybody they would wait. There is something that I get the feeling that there's some agenda. They're doing something. I think the group's working together. After what we just saw with the prosecution and with Ann Taylor, it looked like to me that they had colluded. They had talked with one another and developed a plan for how they were going to ask for this really protracted, long-range court date. Is that what it looked like to y'all? Because the prosecutor wasn't even making sense. He's saying, oh, Judge, and Miss Taylor is telling the truth about how much evidence there is, and it really will take us that long, and it's gonna have to be in the summer. It's not going to be able to be like in the winter when school's in, because we've got football games and we've got the high school that uses a parking lot, and it just won't work. It has to be in the summer, Judge. That's the only way. It has to be in the summer. The whole thing looked like it was really scripted, that they had come up with this little plan on their own. So Jeff H. brings up that exactly true. If BK is innocent, then why is it so damn complex that this has taken multi-years to just get up and present a case for something that took, 12 hours of Bryan Kohberger's life? Yeah, there'll be things that happened before in the days before and whatnot, but it's not like they have to do 4 individual trials. These poor kids, for without a shadow of a doubt, Maddie and Kaylee were together. So that's not 2 separate murder trials. They were together. The same thing happened to Maddie that happened to Kaylee. The exact same thing, whatever the murderer did. So even if what happened with Ethan and Xana is something different, if there were other murderers or whatever you wanted to look at it, you could make that case. But it's still not 4 separate trials. This is the craziest thing I've ever heard. Wow. It's crazy. Can you imagine? Oh, thank you. Can you imagine the lies that must have been, or let's not call them lies because that's pretty harsh. The double speak that the families have received from this prosecutor. I can't believe what I just watched with that prosecutor. I cannot believe I am really, the longer I sit here and stew in it, the more shocked I am. He literally said, we don't have any parking spaces. We don't have any hotel rooms because of the football games. And it's either got to be the summer of 24 or 25 or 26 or the summer of 30 or whatever he's thinking. And then immediately the judge says, okay, well, we need to change a venue. And he just freaked out. He's, oh, no, we don't need that. No, we can get a jury here. No problem. Why, prosecutor? Why did you react so harshly to a change of venue with the proper accommodations? Why'd you do that? Why is it so critical that your jury be made of Moscow residents? Why is that? If you're presenting a case with good evidence and you followed the rule of law, you used the police, law enforcement, used investigation, best practices, standards, you ought to be able to put a jury together anywhere. After all, your jury's not supposed to go by what they learned outside of the courtroom, correct? This is weird, y'all. I only got part of the hearing today recorded. I really thought I'd remain on your YouTube channel. I really thought it would remain on their, no, they took it right down, didn't they? Took it right down. Very strange. I'm not sure I like that either. But I guess, Jeff, will have to be like people will have to be like really careful about getting set up and catching them. And he hasn't issued anything that said that we couldn't record. Has he? I don't remember there being something that's had a recording, saying you can't record it. If they change venue, that means they change the judge. No, the judge would travel with them wherever the new place would be. The judge would still preside. The only thing that would be different is that the jury would be chosen from people that were residents of the new location. It is weird. They tear the house down in this shady kind of, not, maybe I shouldn't say shady. It's a little shady, but there seems to be an agenda. Did you have that feeling that there was something happening that the judge didn't know about? The judge actually said that he was really disheartened. The judge seems irritated with these two attorneys. Wow, why would they do this? This is really, I'm going to have to think about this. This is really something. All right. Jeff H. I left your name up there so I could remember. I went and watched, what is it? So You Got Another One? What? I don't remember the name of the channel now. I subscribe to it. If y'all go to Jeff H's channel, he got invited to go like play guitar with these other guitar players. One of them being Whitesnake's guitarist Steve Vai. You're really good, Jeff H. Like, you are very good. I was notably impressed. So very, very nice. That was a very good way to spend the evening listening to the music. And let me see if I can yes, yeah, there it is. OU812. That's it. So let me get the link, because any of you guys that like music, or specifically, guitars and whatnot, you got to go. This was so great. Oh, that wasn't it. Hold on. I'm looking for a link right now for y'all. Hold on. Just 1 second. I'll get you the link. Let me see if I can remember which one. Wasn't it like 9 days ago, 8 or 9? I think it was. I don't remember which recording this was. Anyway, if you like music, guitars and whatnot, you got to go over and watch, because this was a really enjoyable evening listening to them play, and really, really, really good. Let me see. Was it 7, 8 days? Oh, maybe it was 11 days ago at this point. Yeah, I think this is it. I think this was the one. Hold on. Yeah, this is it. Okay, hold on just a second. I'm gonna embarrass Jeff H here. Hope you don't mind, Jeff H. Let's see. So for any of you musicians out there, look at this panel. This was amazing. So Jeff's on the left in the middle right here. But wow, it was let's see. We'll play a little bit. I was trying to get to, here we go. That
string I've been asked to play on the show. Trying to
How's going on?
just play for sure. Yeah. Floydy thing. E minor, raise it back. Here we go.
The players up.
However.
Yeah, I'm good.
here's the It was really great, Jeff. another one of the authorities. It's like being transported back in time, and the music was really music. There you go. Yes, Kat. Yep. Absolutely, yeah. So easy, isn't it? He makes it look just effortless. So pretty. Wow. Gorgeous. All right. Dude, so good. You know what? I've got to quit listening because I could sit here and listen for hours and hours. So, got to quit. Okay. So, there is the link, okay? And the link that I put in the side chat, that will take you to the video that we were just watching. And I believe, is it not, no, 9, maybe 11 of y'all, 9, or I don't remember how many y'all had. A couple people kind of came in and out later. Yeah, well, 9, 10. At one point there was 10. So it's a lot of, and it is a 2.5 hour jam session basically. And every one of these guys is top notch. Like it was, and so when Jeff H started playing, I was like, wow, like he's sincerely legitimate. so not that I underestimated you, Jeff, I promise, but that level of, that's some talented people. Yeah, that was really great. So I hope that you guys will yeah, that's what my husband said, Jeff. He said, because I said the name of the channel, OU812, and my husband said, it's got to be Van Halen fans. Yeah. So I hope you guys will go over. Did you say that y'all are doing this again on Sunday night again? Is that like this is like a common thing that y'all do, or that was your first time doing it, or what? They do it every Sunday. What time do they start? Okay, so 5 East Coast, 4. Wow, okay. So anyway, I hope you guys, will go over it, and I'll see Cinnamon Hot will probably go watch. But it's very beautiful. They play all different kinds of music. Each one kind of comes in and does their little part of it, and it's a good time. It's very nice. So anyway, we got way off case, but we needed something nice to ground us and get us reoriented after that shocking court appearance and the behavior of that prosecutor. It's just crazy. I think we'll be jamming on a backtrack of Hendrix Little Wing. There you go. Good. I'm looking forward to that. Need some Stevie Ray too. Love Stevie Ray Vaughan. Okay. So that is that for the hearing today with related to Kohberger. If you had asked me, as we were waiting for this hearing, I mean, we did all know that they were going to be asking for try to get the case thrown out, lack of evidence. I wanted to laugh with, this whole idea of lack of evidence, right? And yet, as she says, lack of evidence, you should throw this case out. She says, sir, we have 51 terabytes of what? Y'all say it, put it in the chat. They have 51 terabytes of, what's the E word? That they claim they have nothing. They have none. They have no evidence. And then she says, but Judge, we have 51 terabytes of evidence. So make up your mind, Ann Taylor. You either have evidence or you don't have evidence. One or the other. Can't be both, right? If there's 51 terabytes of evidence, is there something in there that is exculpatory, perhaps? To put that 51 terabytes into perspective, you can house on 1 terabyte, you can house 250 full length movies, like big Hollywood productions, right? 50 in 1 terabyte, you can put 250 Pearl Harbors and Titanic and Superman and the Avengers and Pirates of the Caribbean. You can put 250 full length Hollywood productions on 1 terabyte. And they claim to have 51 terabytes of evidence. So something right there, double talk, right? Out of both sides of her mouth. It's like, okay, what are you doing? Well, she's stalling for time. Normally, the prosecutors don't want that. They don't want to give the additional time. And here we have a prosecutor who stands up and says, we need a parking lot and we need a hotel and we have high school and we have college and this just isn't going to work. And then when the judge says, we need to change venue, he says, no, we don't need to change venue. We just need it to be a year and a half from now. It's incredible, y'all. It's absolutely incredible. So there we have it. That's where things stand. Thank you, Kat. Kat said the word evidence. So we'll see where it goes from here. I'm gonna go, I guess, over to harsh reality. He was playing the hearing, so he probably got the whole recording, Jeff H. So I'm going to go over there and see if I can, steal his and clean it up and I'll put it on my channel as a full recording. The reason we didn't get a full recording on mine is because I stopped to rant. I know. I'm sorry. I get a little passionate about some of these things. You know what I mean? All right. The other person that I'm really interested to see what he has to say is, it's going to be interesting to see what Drip Drop, how he reacts to this ridiculous thing that just happened in the courtroom. So, but we had a nice little mini concert. We got it. We heard us a little bit of good music, so everybody's feeling good. And it is Friday night, and we hadn't had any speculation. I'm gonna have to give some thought to it and maybe come back and do some wild speculation, have a little fun, right? All right. You guys have a wonderful afternoon. I really appreciate you being here. Please go over and check out the music with U812. I think that's what it's called. There it is, the link. And they will be also playing live on Sunday at around 5 Eastern, 4 Central. And Jeff H will be playing with them as well. So that is another thing to look forward to this weekend. And just like, me and Arnold Schwarzenegger, right? I'll be back.